Good morning, my name is Conceição Carapinha and I am speaking to you from Coimbra, Portugal. The title of my presentation is the following: Magistrates' Discourse Styles in Portuguese Courts. Here you can see a brief summary of my work. Language sciences may interact with law in at least two distinct areas: the area which analyzes language as evidence and the area which describes the language of the legal process, both written in law and spoken in courts. Within the latter domain, and drawing on stylistic continuum named powerful speech and powerless speech, presented by Conley and Obar, this paper is intended to study a topic which has, surprisingly, rarely been considered, that of the supposed similarity of the professional styles of those in the legal profession. To my knowledge, there are only 3 studies that propose a typology of judges based on the analysis of their dissimilar discourses: Obar and Conley 1990, Harris 1994, and Phillips 1998. Yet, these studies mainly focus on the way judges interact with defendants and do not pay attention, as I want to do in this study, to the differing discourses of legal professionals when they interact with each other in court in different institutional positions. This is an unstudied subject of Roman law systems, and to shed light on it, I take another theoretical approach. Building on early work by Hale and Gibbons, 1999, and Gibbons, 2003, about the intersection of 3 different contexts that are manifested in courtroom discourse, namely primary reality, secondary reality, and the legal frame, I intend to explain how public prosecutors, who are magistrates as well, exhibit 2 parallel discourses on their own, and how their different speech styles can be related to these different contexts. In addition, the present study argues that we need to analyze the role of discourse in the constitution of power relations and ideology if we want to take a thorough account of the 2 parallel discourses presented by public prosecutors. Now I am going to introduce the background of my study, and I will present you some characteristics of the Portuguese law system. The Portuguese judicial system and the common law system are quite different. Firstly, in Portugal, the written law of legal codes is the basis for courts' daily work. Secondly, the whole judicial process is led by the judge, who assumes the dominant role in court. Thirdly, in the Portuguese penal system, there are 2 magistrates working in the same courtroom. There is a magistrate who adopts the role of public prosecutor in the institutional role for the prosecution, and there is a magistrate who is the judge. The word magistrate is used to refer to both careers, which share the same academic and legal training. Therefore, in Portuguese criminal hearings, we have 2 distinct magistrates who fulfill 2 different institutional roles: the judge and the public prosecutor. At first sight, it is reasonable to think that there could be a natural alliance between them, due to their identical academic training. However, and according to the data available, this idea should be reconsidered if we take into account that there is evidence of quite different styles among magistrates. Talking about language and power in courtroom, I can say that in democratic societies, law courts have power. Their power can manifest by knowledge, by the organizational rules that shape the institution, and of course by language. Indeed, language plays a central role in the arrangement of this social order, which means that law can be defined as a discourse of power. The legal codes and the court spokespeople have power. They decide about people's future, but they also control simpler things like how communication has to take place within the institution. As powerful discourses, they are shaped by a certain legal ideology, that of the legislator or rather the state. Here, I take ideology as a set of beliefs, values, and categorizations defended and opposed by a group or class. This argumentation line is grounded on Eagleton 2000, who, among other possible definitions, presents ideology as a set of ideas and beliefs specific to a socially significant group or class, and as the means to promote and legitimize a group's interests. But if the law is defined externally as a discourse of power, internally we can also easily identify disputes between the professionals which involve speech, signs, and more specifically, meanings. The disagreements between the public prosecutor and the presiding judge show that each participant is willing to legitimize his own meanings, but reluctant to accept the other's interpretations. As we will see, there is a tension between what the public prosecutor can and cannot do regarding the supremacy of the presiding judge. The present study seeks to describe the conversational devices used by both the magistrates to display their conflicting viewpoints, to show their power or their lack of power. The research questions for this study were: A. How do the prosecutors' dissimilar discourses relate to the powerful-powerless continuum? B. How do they reflect legal ideology? The data used in this study were taken from a corpus constituted by 7 court sessions, audio recorded in Coimbra law courts in the late 90s. This sample, taken from the set of criminal hearings, includes 3 different cases. The first, here identified as Hearing 1, concerns a falsification of a Portuguese driver's license committed by a foreign embassy employee. The second is about drug trafficking and involves a father and a son who are drug dealers. The third concerns the robbery of a house committed by a young drug user in a very small village, causing a popular riot. Present at these sessions were a judge, or a collective of 3 judges, the public prosecutor, the accused, the respective defense lawyer, the court clerk, the public, and myself as researcher. In what concerns the analysis of the data, first we will focus our attention on the primary reality and especially on the speech turns of the 2 magistrates, the presiding judge and the public prosecutor. If we look at the moment when the public prosecutor has the right to talk with the defendant and the right to build his own argumentation line, we will notice that according to the legal codes, he is not allowed to address the defendant directly, but only by means of the voice and translation of the presiding judge. This new and strange discourse pattern creates exchanges constituted by 4 turns of speech and 3 distinct speakers, as the following plan demonstrates. The public prosecutor asks a question and the judge repeats that question. Then the defendant answers it, and after that answer is repeated by the judge to the public prosecutor. Example 1 shows this communicative pattern. Initially, it seems that the presiding judge is simply repeating what is said between the 2 speakers. However, a closer analysis reveals some interesting aspects I want to highlight. In our corpus, it is infrequent that the public prosecutor takes control of the proceedings and speaks directly with the defendant. Usually, he plays his institutional role obediently, and he seems to be unable to struggle for greater freedom of action because the judge never loses control of the hearing. We can then say that their institutional roles define their power in court within the primary reality. However, the judges in this corpus do not limit their mediation to repeating the original question asked by the public prosecutor. In fact, They often amplify, specify, generalize, or even reformulate what the public prosecutor said before. See examples 2 and 3, please, and take note of the changes the judge puts into action. As you can see, the judge is always in control. Sometimes he initiates a new series of questions, reducing the other to complete silence. Other times he interrupts his fellow magistrate's initial line of argument and finishes the uncompleted question. He also intervenes when he believes the public prosecutor's question to be irrelevant, unnecessary, or illegal in some way, and it is therefore necessary for him to act, as you can see in example 4. These interventions demonstrate his power, which functions as a linguistic strategy of domination. We can say then that despite being a magistrate, the public prosecutor is unable to get a turn to speak, ask questions, build an argument, and devise his own version of the facts, as these rights are frequently denied him by the more powerful participant. In this respect, we argue that the discourse of the public prosecutor is a powerless speech, in a sense reminiscent of the O'Brien-Conley distinction, for this magistrate's discourse lacks authority. Although he has the same social status as the judge, the same legal knowledge, and similar discursive skills, this particular context does not allow him to use all the linguistic devices he could to build a powerful argument. And this new sense of powerless speech is obviously related to the power imbalance in the primary reality of the courtroom. This power imbalance clearly prevails over their equal status. Within the context of the legal frame, what is linguistic behavior of the public prosecutor? Sometimes he tries to resist his colleague's tight control. He often does this by arguing procedural conditions leading to the production of proof in court directly with the presiding judge. Take, for instance, example 5, which is quite clarifying. Here we find a witness with a higher level of schooling than is usual in a judicial context. She tried to state her version of the facts by legitimizing a relatively dissenting discourse, with the result of forcing the two magistrates to argue the interpretation of the law. Surprisingly, in this specific context, the public prosecutor argues as an equal with the presiding judge. This time, what is most important is to clarify the legal proceedings, to discuss the legal frame, and given the similarity of academic preparation of both participants, the public prosecutor may know the legal matter just as well as the presiding judge. In this moment, both magistrates momentarily leave their imbalanced institutional positions and the construction of the primary reality they were working on to dive into the discussion of legal procedures, which means the legal framing of the event. And here they are, however briefly, in a balanced relationship. They show two opposing interpretations of the witness's discourse, and they exhibit two different ideological positions with regard to the rules of procedure. Why ideological? Because they involve beliefs about how the trial should proceed, because they both want to legitimize their own point of view in order to win the battle, and because this power struggle is led through the medium of signs and through the negotiation of legal meanings. A careful analysis of this sequence clearly shows how power, or the struggle for power, is expressed linguistically and how it is interactively negotiated by means of a series of discursive strategies. The first striking feature is exemplified by the tone of both magistrates. Although we only have access to the written text, it is obvious that they raise their voices when arguing. The conflict is also revealed by a considerable number of face-threatening acts like interruptions and denials performed without redressive action, which means that at this particular moment they are not worried about the other's face and they both are participants of equal status. If you take a look at examples 5a and 5b, you can see an interruption and a direct denial performed by the prosecutor. But there are also negative rhetorical questions, which are used as provocations. By using them, the public prosecutor shows his disbelief concerning the presiding judge's statements. In fact, the repetition of the structure is also significant and face-threatening, as you can see in example 5c. The irony running through this section is also evident. The use of this feature on the part of the public prosecutor demonstrates his ability to defy the presiding judge's authority and legal knowledge. Please look at example 5d. All these aspects display the existence of two parallel discourses produced by the public prosecutor which seek different purposes. There is a discourse directed to the defendant, although this discourse is always filtered through the presiding judge's voice because of the institutional constraints imposed by the court. This speech, used within the primary reality, is what we have called powerless speech. There is, however, a more forceful discourse when both participants sort out from the hearing and engage in a discussion about legal frame, as we have seen example 5. This more assertive speech concerns legal procedures that underlie the hearing. In this moment, since they're out of the primary reality, the public prosecutor abandons his subordinate position within the trial and assumes an equal status, discussing the legal construction through which the world is viewed and managed. Thus, we can identify two different styles in his discourse, one concentrated on the regular running of the proceedings, the powerless style, and the other concerning the definition of the legal framework in which the former takes place, named powerful style. Despite the limitation of the data, we believe this paper demonstrates the need to analyze different corpora, which will certainly reflect the great variety of speakers within the court. First, we showed that when he fulfills his accusatory role, similar to that of a lawyer, and discusses within the primary reality, the public prosecutor exhibits a powerless speech. Even if the distinction made here is not grounded in social factors such as schooling and profession, like O'Brien and Conley's distinction, we still argue that he shows a powerless discourse and that this lack of authority is the result of the power imbalance of the primary reality of the courtroom. But when he discusses the legal frame, he adopts a powerful speech. Within this context, he resorts to some discursive strategies when he argues with the judge about the institutional proceedings underlying the trial. It is clear that these two magistrates work with two legal interpretive frames, one subscribing to the view that hearings should rely on written evidence, the witness testimony recorded by the police, and the other, the judge's view, placing more value on the oral proceedings of the courtroom. The discussion within the legal frame context shows different ideologies which are in dispute concerning the creation of legally relevant meanings. And I finish my study saying that I hope this presentation opens up new questions and new directions regarding the asymmetries of power in courts. Thank you very much.